All right, well, thank you guys so much for being here. Jeremy, I'm going to start with you, and let's talk a little bit about the difference between the legal and publishing rights of a musician versus, as you say, you work with film and TV as well.
So just to clarify, music publishing, to differentiate between music and film? Okay. So I think these days, in my humble opinion, more than ever, music and film are a perfect marriage. Placing music and film, I think, is what makes a film. TV as well. I found that with our changing music industry climate, finding new opportunities and new exposure for music, specifically in film and TV, is more important and paramount than ever. As far as the music publishing issues are concerned, as I'm sure most of you are familiar, generally this entails a sync license for placing the music and TV and film. Sync meaning you're actually synchronizing the music to the moving pictures, be it a film or a TV show. And of course, and this may be oversimplifying the explanation, but of course you're clearing the rights with both the master recording owner, which tends to be the record label, provided the artist is signed to a record label. If not, then with the artist directly, as well as the other side, which is the music publishing side. Generally, these deals are MFN, which is short for Most Favored Nations, where essentially the TV or film producer or studio is paying the same fee for the master recording rights as they're paying for the music publishing rights, hence Most Favored Nations between the two sides. I think these fees vary widely based upon the circumstances. If it's a very prominent opportunity, then perhaps the music publisher and the master recording owner won't be as, say, hell-bent on maximizing the fee, and they'll see the forest from the trees as far as the opportunity is concerned. And then those TV shows which tend to license a lot of music, such as reality shows, talk shows, etc., generally there's just one low quote that is MFN for all the songs, right? So there's not much negotiation that goes on. Then you have certain copyright holders who are more protected than others as far as what they're willing to license their music for. Things may be very personal to them regarding politics or which types of products. Some people may not license their music at all. They want things to be very, you have certain legacy artists who have not even allowed their music to be exploited or streamed or downloaded or sold on various new technology platforms. So it's a wide array, but ultimately music publishing is the lifeblood of the music industry. Copyrights, copyright holders, and great American songbooks, standards. These tend to be the things that survive from generation to generation.
That was great, thank you so much. Matthew, I'm going to come to you, try to further elaborate a little bit on publishing and copywriting between a musician and, say, a label. If you're an up-and-coming artist, you're recording a demo, you're recording an album, what's the next step in copywriting your music and making sure that your relationship between you and record label is putting your music out there to protect your rights?
So, all right, when you're an artist and you're writing your own material, put this water down before I spill it all over myself. You're always dealing with two separate copyrights when you're both the writer and the artist. You've got your song, then you've got your recording of that song. So, as far as protecting yourself, of course there's copyright registration. You'll want to register both your song and your recording. If it's a situation where you are the only artist, in other words, you're not part of a band, and you're the only songwriter, then there's ways you can register and you can kind of streamline the process and register as a collection, save a lot of money. Otherwise, if you've got co-writers or other people who might be a co-owner of those recording copyright, then you've got to file each work separately just because of the multiple owners. What was the rest of your question?
Elaborate how the contract is going to protect your rights by publishing copyright.
Depending on what level of an artist or a writer you are, you're going to be looking at different ownership provisions in your publishing and artist agreements. In your publishing, if you're a new writer, most likely the publisher is going to want to own 100% of the copyright, and they're going to want to pay you 50% of the money that comes in. Of course, that's what's separated out of that is your performance royalties, which come from BMI or ASCAP. You'll continue to get those directly, usually. Now, everything's kind of changing nowadays. I've recently have been doing more and more outside of Nashville deals, and there seems to be a whole lot more co-publishing, even for newer writers, when you get outside of Nashville. So, you know, it's not a one size fits all. You got different genres of music have different practices on, you know, what a first deal looks like. But you know, since Nashville is the closest to Asheville, if you're doing a deal in Nashville, then you're most likely going to have to give up 100% of the copyright. The publisher will handle all of the things, you know, as far as registration, setting you up with ASCAP and BMI, making sure your songs are registered. That's, you know, it's not enough just to join ASCAP or BMI. You've got to make sure that your songs are correctly entered as far as, especially if you have co-writes, making sure the percentages add up to 100%, not 99, not 101, because they like to hold on to the money when you know, get those numbers incorrect. As an artist, you want to make sure you're affiliated with Sound Exchange. That's where you're going to get your money from. Pandora, satellite radio, any kind of digital performance of your record, you're going to get a royalty as the artist, and if you own the master, then as the copyright owner as well. Anything other, or is that good?
That was pretty good. That was pretty good. Thank you very much. I want to continue to further elaborate on that with Jeff. And maybe, Jeff, perhaps you can, in layman's terms, explain a little bit about performance royalties related to ASCAP, BMI, and how that relationship with a recording artist or a songwriting artist is important.
Yeah, I was actually going to make that suggestion. I would stress the importance of affiliation with one of the performing rights organizations. The three majors being ASCAP, BMI, and then CSAC is the third. There are some smaller, newer performing rights groups that are forming that are privately held and relatively exclusive. But when it comes to ASCAP and BMI, you don't have to be invited to join one of those organizations. You do have to be a published writer, and published is a loose term when it comes to that requirement. But they're fantastic organizations that, number one, protect and collect performance royalties when your copyrights are licensed and for public performance. But they can, which can mean a lot if you are commercially exploiting your copyrights and there's money to be collected. Up until that point, they can be a fantastic resource for things like this, providing you information about protecting your copyrights, providing creative services in the way of introducing you to publishers, sometimes even introducing you to other songwriters. Excuse me. In Nashville especially, they are sort of the entry point into the songwriting community. So I would, depending on whether you come to Nashville or you spend time in New York or Los Angeles, or even some of the other more major music markets like Atlanta, they have really strong PRO offices there. I would make it a point to affiliate, try and get to know someone there if you can, even have someone designated as your member representative. It's just fantastic organizations. And again, I don't know how much we want to go into it, but when it comes to actually collecting your performance royalties, obviously, this is critical stuff, right? It's a very complicated system. I won't even begin to explain how performance royalties are collected and accounted for, but someone has to be out there collecting those fractions of pennies for you. And ASCAP and BMI and CSAC are experts and exclusively the ones to do it.
And if I could just expound upon that briefly, about this music industry climate we face, and it's ASCAP and BMI being by far the two largest, and to give you some sense of scale, each of ASCAP and BMI collects just in excess of about $1 billion annually in performance royalties. CSAC being a lot smaller, yet in my humble opinion, more active. CSAC, which is Nashville-based, is of course private, so CSAC chooses which songwriters to affiliate, whereas ASCAP and BMI are public. Anyone can affiliate. And some of those smaller, privately held PROs to which he referred, one, of course, most notably is Irving Azoff's Global Music Rights. And if you're not familiar, Irving Azoff is one of the most legendary music managers of all times. And he's done such things with Global Music Rights as radical as pulling the YouTube license for all of his songwriters, which created a great deal of leverage to negotiate more favorable deal. And speaking of, just as a final aside, ASCAP and BMI and CSAC for that matter, they are on the forefront of protecting songwriters and publishers' rights, lobbying Congress, helping enact new laws and legislation. And these things may seem far away, distant, DC related, but when in fact they are critically important to songwriters earning a living, and ensuring that any kind of exploitation of your songs is compensated for properly, whether it's music being played at a ballpark or at a concert venue or on a streaming service. And of course, I hear it time and time again, even on my trip here from Los Angeles. Consumers are consuming very different ways these days. So things are largely streaming, right? It used to be much more traditional. A song would spin on the radio and there'd be a specific royalty rate triggered. These days, everyone essentially is chasing the technology and trying to figure things out retroactively or after the fact. It's very frustrating for the songwriters, the recording artists, and in turn, their representatives, because frankly, we don't have all the answers and things are being figured out and changed in real time.
That was excellent. Thank you guys very much. Just to further elaborate on this a little bit, I'm a venue manager, so I deal with ASCAP and BMI. On the flip side of that, I pay a percentage anytime I'm playing an iPod, anytime I have a live performance. So what's the difference between how they keep up with royalties per artist as they take in these many wide swaths of how they accept royalties?
Who wants to take that?
I'll start.
Feel free to help each other, you know.
One thing that I think is relatively new being 5 or 6 years, is when you're a singer-songwriter who's mostly going out and playing in places like this, you're not getting your song played on radio stations across the country. You still can get the benefit of ASCAP and BMI by turning in your set list. You keep track of the dates you play, the songs you play. You upload the information on their website, and it's not going to be a lot of money, but it's something that you get even when you play at a small venue like this. Now, for venue owners, I think the reason they do that and are happy to pay writers for that is they want to make sure you have a license.
Yeah.
So that they get, they get the set list and they see when and where, and if they don't see that there's a license issue, then they'll give the venue owner a call and say, hey, we know that there's live music being played there. You need to have a license. And that's even more of a benefit to writers because that will get more licenses issued. ASCAP and BMI they'll try to work with venues and get, get people to come to an agreement, but they will also file suit and do what they've got to do to get licenses out there.
Go.
Yeah, I would say too, for developing artists and those who have aspirations to do this, nationally or globally, it's probably a good idea from the earliest days of your career to start, at least making the attempt to protect your rights and setting yourself up for success. And that could mean affiliating with one of the PROs, registering with Sound Exchange, even if you don't necessarily have anything that needs to be collected yet. Getting in the habit of registering your songs, keeping track of your copyrights. If you co-write with people, determine the copyright splits with your co-writers, and also do what you guys are doing here today, and that's learn about how to protect your rights when it comes to contracts and not signing things that you don't understand, budgeting out a little bit of money for an attorney every once in a while. I mean, you guys are, and I don't want to make the assumption that everybody in here is a developing artist. There may be some very established artists in here. But you're starting a small business, right? And any small business needs to budget for legal, or at least find a way to ensure that you're not signing something that you don't understand or don't agree with. So I applaud you for being here today, and I would encourage you to sort of stay on top of keeping up with your rights, protecting them, and tapping into resources that can help you with that.
Also, the award shows are great. ASCAP, BMI, and CSEC. I recently attended the ASCAP Pop Awards in Los Angeles and plan to attend the BMI Hip Hop and R&B Awards in Atlanta in August. Really a great opportunity to meet some of your peers, other fellow songwriters, recording artists, as well as, of course, all the professionals, publishers, managers, agents, publishers, etc. And also just to see people receiving awards and which songs are most performed at radio. It's a very eye-opening experience, even for me doing this as long as I have. And it's fun to see the community ethos and vibe, everyone looking out for one another, and ultimately that's what this is. It is a tight-knit community, and we all tend to know one another. It's a very small world. As you get more established, run into the same people, and that leads me to another point, which is how important it is to be diplomatic. This was never meant to be riddled with conflict, right? The conflict tends to be with the folks who are supposed to be paying for music and may not be paying or not paying as much. But as far as this music community, I think we all do it because we love it. It's certainly not to maximize our revenue, right? Just speaking for myself, I think I'd probably be back on Park Avenue in New York wearing a suit as a partner in a law firm if it were all about the salary. It's really protecting our clients. We're ultimately artists and songwriter advocates, and those sorts of networking opportunities, award shows, etc. It's really a wonderful opportunity to remind yourself that's why we got into this, and we're just ultimately celebrating the music that we all make, or the music that we represent.
Awesome, thank you so much. And I definitely hear a number of points where it sounds like keeping up with your data, staying active with how you keep up with what you're doing with the songs, who you're writing them with, set list, all that is obviously crucial to an artist to make sure that down the road you're getting your rights to your music and obviously the royalties in hand. Jeff, I heard you touch on one thing. He said, if you don't understand it, don't sign it. So I had an interesting situation with a friend who's a recording artist, recently recorded here in town, did some final mixes in Nashville, and went to sign his very blanket statement of BMI, to register with BMI. There was a number of clauses that kind of stood out to him. All of them, in my mind, protected him, but what are the kind of things that people should look out for when you're in that situation and you get this 5-page, very blanket legal document when it comes to keywords or making sure that you don't sign the wrong piece of paper?
Yeah, I mean, it really depends on sort of which aspect you're working on in the industry. But you know, some of the things that would be put in front of you that you'd be asked to sign, maybe on a moment's notice, are like work for hire agreements, which it's essentially calls for, on its most basic level, for you to assign any rights that you might have to that particular content to whomever it is that's asking you to sign the agreement. You know, I guess there might be some media rights that you might need to be looking out for if you're performing at certain venues, if they're recording your show, if they plan on streaming your show. They may ask you to sign something before you do that, and you know, for the most part, depending on how valuable those rights are, sort of beyond that particular use, what you're being asked to sign might be rather innocuous. But I know, for me personally, as someone who primarily represents artists, you know, summertime is a really busy time for me. I'll get an agreement from an artist manager, someone playing a festival that night, and I need to review an agreement that deals with their media rights, you know, name and likeness, and the festival's ability, or someone the festival has hired out to live stream or record and replay that particular content. And my artist may be signed exclusively to a record label, or my artist name and likeness rights may be valuable enough where you wouldn't want them to be exploited, you know, without further compensation. And these things, you know, even for artists that have, you know, reached a level where you would expect, I suppose, a good bit of time to review these things, they get shoved in front of the artist or the artist manager, you know, 30 minutes before the set time. So, you know, from the standpoint of a developing artist, it's, you know, I think probably less respect is given, I suppose, when it comes to, you know, pushing a piece of paper in front of them and expecting them to sign it. And, you know, I would just encourage you, the best you can, you know, back away and not sign anything that you don't understand, and certainly ask for the necessary time to read through it, consult with someone if you need to, and at a basic level understand what it is that you're being asked to give up.
I think that's an excellent point. Work for hire, major red flag. Another one is the word standard. Run, when someone says this is a standard contract. All joking aside, nothing is standard. There may be something that people are accustomed to signing, but everything is ultimately negotiable. Everything is case by case, and it's all based upon leverage. If someone wants a deal with you badly enough, he or she or they will negotiate with you. There has to be a bit of leeway to negotiate. So also be wary when someone says that you don't need a lawyer because this is standard. That is another thing that you should be very, very wary of. When it comes back to your question regarding the standard contracts for ASCAP, BMI, and CSAC, in my experience, the most important facet is the term. So the amount of time that you'll be affiliated with that PRO, be it ASCAP, BMI, or CSAC. There's something called an election period. That is something that if you don't know, you'll get to know very well. Or God forbid, as an artist representative, if we don't notify our client of the election period. That is the time window within which a songwriter can resign from ASCAP, BMI, or CSAC. And it's a very specific, generally 3-month window. And if you miss that window, if you do not resign within that window, then the term automatically renews for another 2 to 3 years. So can you imagine the surprise when someone's expecting to be out of, say, ASCAP, for example, at the end of his or her current 2 to 3 year period, misses the election period, and then automatically renews. So something to pay very close attention to, or to ensure that your representative does. And then regarding any kind of deals, whether music, TV, film, etc., exclusivity, extremely important. Obviously, representing the artists, we want things to be as non-exclusive as possible. So we have the ability to have all sorts of contemporaneous commitments. So we're doing things at the same time for any given song, for instance. So the devil really is in the details, as cliche as that is, and all bias aside, but having a savvy legal mind review these things is hugely important.
Awesome, thank you guys so much. We've been touching a lot kind of on recorded materials. Let's talk a little bit about performance. I'm a local artist. I perform 200 dates a year. I'm frequently playing in both large events and small events. What can you do as far as making sure you have at least legal counsel enough to develop a contract to protect your rights, and to making sure basically that you get paid? What does that contract do to protect you?
As far as getting paid, you want to make sure that you get a certain, usually you'll get paid 2 different time periods, right? You'll get paid soon after the show's booked, you'll a 50% deposit, and then you'll get the remaining 50% the day of the show. And then there's also, live performance agreements are probably more varied than anything else. You're going to get paid one way for a small show at a place here as opposed to in a festival or something like that. But you want to at least get some kind of deposit so that you're not out of money getting to the show. And everybody's heard horror stories of getting there and then you don't get paid. Then you got to, it's a lot cheaper to have us help you before you do the show than to come to someone like us and say, I need to sue them because they didn't pay me for my show. But I think that's probably the most important, is making sure that you're going to get money up front. And then the things that they were talking about as well, with media rights and things like that, especially as the shows get bigger, they're more likely to be recording or videotaping or something like that. And you're going to want approval rights on how they use your image and biographical material and your name. You're going to want to make sure you're not getting tied into some kind of product endorsement that you didn't realize was involved with the show. You just need to look at things other than how much am I getting paid and how long is my set and things like that. Anybody want to add?
Yeah, I mean, I personally, in my practice, I don't deal with too many live performance agreements. A good number, if not most, of my clients have booking agents who see and deal with those performance agreements, unless the agreements, come with some sort of media right aspect where they are going to, live stream or rebroadcast that particular performance. I usually get calls when something goes wrong with that sort of installment payment process. A show was canceled for whatever reason, or my clients, which they never would do, but breach their agreement, or there's some occurrence outside of either the promoter or the artist's control that causes the particular performance to not happen. That's when I typically get a call. But on a daily basis, as I'm sure Ben, you can attest to, you're dealing with an agent, and it's the agent that's reviewing and ultimately signing off on that agreement.
Yeah, absolutely.
My protocol with my touring artist clients, if it's a one-off concert date, generally to your point, I defer to the artist booking agent. If it's more of a proper tour, I insist upon being involved with the utmost respect to my client's agent. He or she, it's a volume business, agents. Managers and lawyers tend to be a lot more involved on a day-to-day basis. And we factor a lot more into it. We try to see the forest from the trees as far as their career is concerned, not just maximizing the dollar amount per show. So, and back to your point about the 50% front end and the 50% back end for shows, the two largest concert promoters in this country are, of course, Live Nation and AEG. So Live Nation, for example, will only pay a 10% deposit And you may say to yourself, well, that's unfair. I, the artist, am incurring all sorts of costs, and what happens if the show doesn't go down? Well, they don't care, because they're Live Nation, and either you want to deal with them or you don't. And they own a certain percentage of the venues, and that's the deal. So that's what we essentially have to relay to our clients diplomatically. It's a very good point regarding product endorsement. Also on tours, even scrutinizing, depending on the client of course, scrutinizing over what will appear on stage, what will appear in the entrance and foyer of the concert venues, because you have to put your mind, you have to put yourself in the mind of the consumer. Will the consumer think that your artist is affiliated with a certain product, a product which may not necessarily align with the client's career or interests or beliefs? These things are hugely important. Yes, often with getting back to exclusivity, if there are all sorts of entanglements, you need to advise the client. If anything is running afoul of that exclusivity, whether it's a television show, whether it's you're going to want to carve out certain things like, say, talk show appearances, which may be required to promote an event or a tour. So you have to kind of have a bird's eye view of the artist's career, knowing where all their deals are, the status of those deals, the exclusivity, and making sure that none is running afoul of the others, so you don't find yourself in breach territory where you're playing defense, and ultimately the client's often paying for other lawyers. I'm half joking when I say a big problem arises, and I'll say to the client, hey, that's not my area. Ultimately, I hung up my litigator shoes long ago, and when things get too hectic, we need to retain litigation counsel, which is generally a lot more costly than us.
Awesome, thank you guys so much. Just real quick, for an up-and-coming artist, low budget, what's the most important thing you can do legally to protect yourself in the beginning, getting started?
I guess one thing you can do is read a lot. I get so many questions and phone calls from people that all they really had to do was just a quick Google search and found their answer. Read, and then read some more and read some more. There's books out there that are helpful. Everything you need to know about the music business is a good resource for people. I'm sure all three of us are the same. We understand that a lot of clients that are up and coming can't pay us, at least can't pay us our full rate. And still, we will find ways that we can help and work with them with the hope that when something does happen, then they'll, have us do that deal, and, we might get rewarded on the back end for having faith in the artist and the money. You need to find lawyers that are in this field, get to know them, and there's a good possibility they'll help. I mean, they can't spend all their time with you, but they can help you. But anytime you do something with your music, you need to think through what kind of paper do I need for this. If you're an artist and you've got your friend producing your album, your EP or whatever, that's an important relationship between artist and producer, and that needs to be on paper. Even if it's your best friend, your brother, your sister, your mom, your dad, whatever, there are copyright repercussions with the master, there's royalty rates, there's all sorts of things that you want to make sure you take care of. It's a business all about creativity, but it's also a business, and there are things that need to be in writing, and when it's dealing with copyright, it always needs to be in writing.
Yeah, I would say too, find people within the industry that you can trust. To a certain extent, we're all in the dream making business, and due to that, there are people that can manipulate you and take advantage of you because, we all, and to a certain degree, I would say we're probably in the same boat. It's a tough business to get into and to sort of cut through, even whether you're on the business side or certainly if you're on the creative side. When someone starts to pay you attention or indicates that they like you and then they can help you, you have a tendency to believe them, and sort of, cozy up to them because someone is sort of giving you at least what you think is, maybe a path, to fulfilling your dreams. And that's easy to be manipulated. So I would, find people that you can trust. This organization is fantastic, and I certainly applaud what it is that you're doing. And I would say stay active here and rely on these people as much as you can. And then, do your research. Like Matthew was saying, read up the Pastor book. All you need to know about the music business is a great resource. And then, find people that you can use to name check. If someone wants to manage you, seek some resources from that person. However you can. It's really, really tough sometimes to unwind those early relationships that you form when you're developing as an artist. Please, if someone is asking you to sign a management agreement, or an exclusive recording agreement, or an exclusive songwriting agreement, get a lawyer. Get a lawyer.
With respect to up-and-coming artists and the ability or inability to fund legal fees, just speaking for myself, I invest in people, not necessarily in fees, right? I recognize not everyone has the luxury to do that, but ultimately, I worry about fees later. I try to be a keen judge of character and assess as quickly as possible if this will be a mutually beneficial relationship. And again, the amount of initial fee does not really factor into that. Ultimately, as cliche as it sounds, the money comes later. You build these relationships, you network with people. One thing that I've always done, which has worked for me, is I never start a relationship with my hand out, meaning I never ask for things right off the bat. In fact, I like to do the opposite. I like to add value. I like to really ingratiate myself with someone and to be a resource or an asset to this person. And I find that far more often than not, I'm paid back in spades, so to speak, because ultimately that's a relationship. We are used to being solicited. We're used to people coming to us, wanting us to do things for them, who may or may not have any fees for us to do those things. So ultimately, I'll give you one example, which may or may not be apropos of anything. As I was making my transition from music to film, I still do both, and I didn't have nearly as many film relationships as I do now, I thought I would utilize and leverage my music relationships as best as possible. So one such prominent actor-manager, I knew he was very keen on attending Coachella. What a surprise, right? People love Coachella. I heard through the grapevine that he was looking for those coveted VIP passes to Coachella. And I was just establishing a relationship with this individual, so I took it upon myself to procure 7 VIP passes to Coachella for him. I did that without him asking. I knew he was beyond thrilled about it, and ultimately, it was just unwritten law. He understood that he'd be doing things for me moving forward, and I didn't even need to ask. So anytime I wanted access to, say, one of his actor clients, it was not even a discussion, because I had ingratiated myself. And that may seem like kind of an extraordinary example, but ultimately it does come down to the people and your relationships. And I'll say about PROs, ASCAP, BMI, and CSAC, which we've touched upon, as well as record labels, music publishers, management companies, talent agencies, PR firms. It's not about the company, it's about the individual. So you made an excellent point about ensuring you have a designated representative, say at ASCAP, BMI, or CSAC. Because ultimately, two songwriters will have, or two recording artists, whatever the case may be, will have vastly different experiences with the same company based upon which people are looking after you. These people need to, as we do, we need to have a vested interest in you. It can't just be about the dollar amount or the fee. It has to be, I really believe in this person. I want to see him or her succeed. So that, to me, is way more important than front-loading fees. That all comes if you have a mutual respect and rapport and belief in one another. So that's what I say, being able to be a keen judge of character and talent and going out to see shows and assessing things, but also not abusing the privilege, right? Knowing that if we're, say, working pro bono or on the arm, not to, hassle us as though we're seeing a bona fide commission from you.
Awesome. That sounds like great advice, guys. I want to make sure we take some time to open this up to some questions. We do have a microphone right up here at the front of the stage. If anybody has any specific questions, can be anything related to legal contracts and your experiences. These guys are here to answer them for a moment.
Anyone? I'll ask a question. So, for up-and-coming musicians, can you write your own contract? What makes a contract valid?
I mean, without taking you guys to law school or without me having to rely on what I learned in law school, a meeting of the minds and consideration paid creates a binding agreement. As far as writing up your own agreements, I don't recommend it. And I think, to Matthew's point, I do think that Google can be a fantastic resource. It can also be a terrifyingly bad one. So, if you're going to pull something off the internet, a form, which there are plenty available, I would double, triple check, what it is that you're pulling off of the internet is actually valid, and it isn't going to get you in more trouble than good. So, I would avoid. This is, it's also, it sounds like a self-interested answer, but I would avoid drafting your own agreements. Would you guys agree with that?
I couldn't agree more. Really, it creates so many more problems.
Just to segue quickly, the biggest issue, of course, is, and we get this a lot, this is actually a perfect segue. So it's very clear right away when someone asks for something that he or she doesn't want to pay for it. Hey, can you just send me a form? I get this all the time. And I have to, of course, maintain my composure and say, well, there really is no such thing as a form. Because ultimately, while a contract may start off similarly, once the negotiation ensues, then what? Right? Because you change one word here, one clause here, and then all of a sudden things don't reconcile, and ultimately the contract doesn't make sense, and dare I say, maybe unenforceable. So yes, there may be a very initial preliminary form, but ultimately it's all about where the negotiation takes you. Again, it's a great response. This may sound like a self-interested answer. Basically, we are the gatekeepers to contracts, but ultimately, it is all bias aside, and as objectively as I can be. It is a worthwhile investment to have a properly lawyered contract, because you will prevent or preempt all sorts of issues, no doubt. And those people who you think, oh, so-and-so is my friend or whatever else, you'd be surprised the effect that emotion and resentment have on friendships and family. So you want things to be, the basic principle of a contract is, and again, not to sound too Watergate, but such is my game, you always want to assume that a contract will end up in court. And why do you assume that? You want things to be as clear and unambiguous as possible. You never want the court or the judge or whomever is presiding to substitute his or her or their judgment for that of the contracting parties. So you want the language to be as specific and clear as possible. So later on, someone would say, well, what do they mean that the term is 2 years from commercial release of the album? Did you mean initial commercial release? Did you mean from the day the album was streamed, or from the day it was sold? Because streaming can technically accrue royalties, so isn't that commercial? Or do they mean the actual street date of the album? The devil's really in the details. So, and I'm going to go out on a limb here and say that non-lawyers will find it very difficult to craft a very clear, unambiguous contract that would be enforceable.
And this also brings another one from me. Let's say you have a contract, obviously, but you also perhaps have an email chain going that describes some terms that may or may not have made it into a contract. This is something you missed. Is negotiations that are kept on record, are those admissible in court? Are they going to hold up, or is the contract at the end of the day the final binding agreement?
Typically, in a professionally drafted contract, you're going to have language that says to the effect that any negotiations up until the time of the contract is signed are superseded by the contract. In other words, the contract's going to override anything that you had up to that point. Now, where things may change is if there is some ambiguity in the contract, then they might go to other sources to see what the parties actually intended.
Yeah, very well said. I think it's a common misconception that cobbling together text messages and emails and whatever else constitute, in the aggregate, a contract. And I'll say this, getting back to my thesis here about investing in people. Ultimately, as crass as this may sound, management agreements, since we've used that as a running example here, they're often not worth the paper they're printed on. It really comes down to the individuals. If someone wants to hold your feet to the fire, it is really, to me, it's not advisable. I'm not saying that you should just let someone go despite having a contractual obligation. However, I think it's important to remember, and this may sound funny coming from a lawyer, but be reasonable, be diplomatic. Once you let emotion and anxiety and desperation cloud your judgment, it's going to be a lot more stressful and more costly for you in the long run. So I think and this is easier said than done at times, but ultimately, I'll give you an example. A dear friend of mine who's passed away, a legendary hip-hop manager called Chris Whitey, who managed everyone from LL Cool J to 50 Cent to Mariah Carey, on and on. Anyways, Chris said to me something I'll never forget, and this is a guy who's represented some of the most meaningful urban talent in the world. Said, you know, Jeremy, I've never had a contract with any one of my clients, and I'll name check a bit, and he was specifically referring to 50 Cent, and they of course did their vitamin water deal together, which, as you probably read, yielded hundreds of millions of dollars. And they said, listen, if someone else wants to deal with 50, good luck. And I feel the same way. If you want to hold someone's feet to the fire and say, wait a minute, we have another year left in our deal, that's fine, but see the forest from the trees. So again, this is not in any way I'm not saying that you don't need contracts, but ultimately, invest in the people, know who you're getting into business with, be wary of people who present contracts right away before you know one another. What is that? How can you commit to someone before having rapport, before knowing what makes this person tick? And that very much applies to our prospective clients as well. Fortunately, it's not about the money for me these days. It's about, is this going to be a favorable experience for me? Am I going to cringe every time this person emails or calls or texts me? You can't put any price tag on their sanity.
Sounds like relationships and resources are probably the two most important things to remember. Contracts are really just a way to protect those. Do we have any other questions from the crowd for now?
This may be an obnoxious question. What is a ballpark figure for the kind of retainer that would be required to secondly, is there an organization that catalogs all of you guys so that you're on some page full of entertainment partners?
Fees. You know, it's a broad range, you know, depending on where you practice, you know, whether you're a solo practitioner, whether you're with a boutique firm or, you know, a major international law firm that has areas of practice outside of music. It depends, quite honestly. You know, some attorneys will only take you on a percentage basis, meaning they take what's typically 5% of what you make as an artist across the board. There are some attorneys who will only work on a billable hourly basis. You see a lot of music attorneys do what's called value billing or flat fee projects. So if you came to an attorney with a publishing agreement, assuming it's a fairly, and I know we don't use this word, but standard agreement, you know, you sort of know who the publisher is, and you know what their agreements typically look like, and how long it might take you. They'll just, you know, charge you a flat fee essentially, so you won't pay any more or any less than what it is they quote you. I don't know, their billable hourly ranges. God, I don't know. From, you know, $100 an hour to $1,000 an hour. You know, depending on where you are. Again, which market you are, you're in, and who it is you're trying to hire.
One thing too is if you're dealing with a reputable publisher or record company, usually you can get them to pay at least part of your attorney's fees as an advance. So. Say your lawyer's going to charge you $3,000 to do your songwriting agreement, they can build in an advance in the publisher to pay that for you, so that you're not out of pocket that money. But, you know, depending on what, I mean, if you have a one-page work or hire agreement that you're going to have an attorney look at, that's one thing as opposed to a 30-page agreement that they've got to read through, mark up, negotiate with the other attorneys, and go back and forth. You know, that can, of course, get expensive very quick. Someone with a question like a work for hire, I'll usually, after I make sure I don't represent the other side, I'll have them send it to me, read through it, get back to them, and not charge or something like that. You know, that's usually a one-page, easy thing to do. But, you know, there's no, I guess, one answer to cover fees, which usually is our least favorite thing to talk about.
Just to add my 2 cents, when I was with a large law firm, it was all about hourly billing. That's the pyramid scheme that is a law firm. You have the, this does not sound cynical at all. It's you know, of course you have the partners at the top of the pyramid who ultimately delegate the work to the worker bees, the associates, who they bill out at a certain billable rate, which, to your point, varies widely based upon the market. New York, LA, San Francisco, which tend to have the highest cost of living, and then generally the lawyers' rates reflect that. These days, however, where most of us are at small boutique entertainment firms or solo practitioners, to me, the hourly rate is really at this point more of a barometer, so you can accord a certain value to my service. I'm rarely billing hourly because, frankly, it's cost prohibitive. Very few people would be able to pay me $600 an hour, which is my rate. And that may be jarring, but that's ultimately what someone of my experience in my market would be paid. However, I rarely actually utilize that. But when I am factoring in, say, a flat fee, it's loosely based upon that quote value for services. So if I say, I anticipate this taking me between X and Y hours, here's what I would make hourly, and I'm going to charge you this much less. So it may seem like a bargain, even though it's kind of all semantics, right? I mean, ultimately, it's what someone's willing to pay. It's how vested we are in something. If we're willing to kind of go out of our usual range. For me, more often than not, I'm a commission guy these days. The 5% that you referred to. I find that when I have more corporate clients or clients maybe on a one-off basis, where it's a referral, I may not necessarily be handling any subsequent matters for this client. It's probably a flat fee. Of course, very important thing to note with commissions, and this is a common misconception that I've encountered. Say using that standard 5% legal commission, many clients are under the mistaken belief that 5% only applies to deals that you handle. That would, of course, defeat the very purpose of the commission, because there are many deals which don't trigger any kind of payment or advance or royalty. So how do you reconcile that as a lawyer? You say, okay, well, what would my commission apply to then? Ultimately, 5% of every dollar that the client earns, no matter the source, is meant to subsidize all the work that you do, right? So, for instance, when I'm handling trademark work, there's no advance commission from that, but still a lot of time and diligence and expertise. So ultimately, the 5% across the board, as I say, is meant to subsidize all of your work. So to me, I'm more often than not a commission guy. Sometimes flat fee, rarely hourly. And again, hourly is more of a barometer for the quote value of the service.
Cool. And then, what's a good resource to find musiclawyers.com?
Google.
And we'll help you. We'll help find you someone.
The state bar associations usually have a directory of attorneys that will list their practice areas. That's one way you can look. But really, when you're in a group of people who do what you do, the best thing to do is to talk to people, see who they use, see what they think, and get feedback from other people.
Yeah, the aforementioned PROs too can be helpful. You can reach out, I'm sure they can give you a referral. I didn't know there is a data. I mean, lawyers.com I think probably keeps track of all of us, but I haven't checked since I was a young pup lawyer. Maybe we should start one.
But just the three of us.
Touche. I would say nearly all of my referrals are from personal relationships. I know nothing about these databases. I don't maintain any profiles. I'm not on LinkedIn. I'm not. This is niche of niche what we do. You'll hear a lot of law students or even lawyers who say, "Oh, I want to practice entertainment law." It's not something. And again, this is all ego aside. It's not something that you just decide to do one day. There has to be some kind of connection. For me, I worked for a guy called Russell Simmons for a long time. That's ultimately my mentor in the music business. I was working for him while attending law school in New York City. And ultimately, so I had those music industry relationships that I then applied my professional skill set and law license to. Entertainment lawyering requires mentorship. Again, it's not something you do. You need to learn from other entertainment lawyers. There's a lot of trial and error involved. So virtually all of my referrals come from existing clients, or friends of existing clients, or people who may know me by reputation. And frankly, whenever someone contacts me out of the blue, if it's not through a friend, or a friend brokering a warm introduction with a potential client, I tend to ask, do we know one another? How'd you hear about me? I'm always, I am diplomatically skeptical, right? Because it's also very important to me who I get involved with and who I affiliate myself with. Getting back to that thing about being a keen judge of character. I've been sued before by taking on the wrong client. So, yeah, it's a very serious matter to get my malpractice insurance carrier involved through no wrongdoing of my own, but just not being a keen judge of character. Great example. He should remain nameless. But a very, very prominent record producer who's won a slew of Grammys and been behind all sorts of hits, When he was referred to me through a mutual friend, my knee-jerk reaction, this is great, so-and-so, some of my favorite records he produced, etc. Well, I knew about that he had fallen into some times and this and that, and there were some stories, but I gave him the benefit of the doubt, which I've come to regret. Long story short, I lowered a deal for him. It was a producer deal. You'll find this a lot as well with very established producers. Everyone wants access to them, so there'll be some investor or financier or wealthy parent who wants their daughter or son to work with this producer because he's behind those big hits. So they'll pay them a big premium to work with their unknown artist child. And in this particular case, my client was happy to accept the $100,000 per song from this client. But then he decided not to deliver the songs. It's a bit of an issue. You're paid for a service and you don't render the service. So simply because I drafted the deal, somehow they decided to sue everyone. Again, we also need to protect ourselves, as you all do. So just by virtue of having my name on a contract as the care of address for this individual, as a mere scribesman or scrivener, to use legal jargon, someone who just drafted the agreement, somehow a liability was attributed to me. Anyways, so again, all personal referrals, really, and with me, I would never contact someone out of the blue because I don't think. I think more often than not, you won't get a response. I think a warm intro, you'll always get a response. When you have someone to vouch for you, so develop a rapport, a relationship with someone. Even the art of the networking, right? So if there's someone you're targeting, then get to know someone who knows that person. Right, and then potentially that person will vouch for you and introduce you. That to me is the way, especially with the lawyers, because we are also assessing the source of the referral. At least I do. Is this someone who I trust? Is this someone who I've had all sorts of successful dealings with? Then I'm happy to take that calculated leap of faith and get involved, as opposed to someone who I don't know from Adam, so to speak.
Those are all great answers. I want to make sure we leave a little bit of time for everyone to have an opportunity to come up to these gentlemen in a little more of a social scene. Did you have a question, or you just?
I mean, if I can phrase it right, more about publishing. You mentioned giving up, that most of the time you're going to have to give up 100% of your copyright to a publisher. Is that the case across the board, or what about a more indie situation? Can you self-publish? Can you go around that when you're starting out?
Well, if you're not signed to a publisher, then you are self-published. So yes, you can always self-publish, and you just need to always make sure you do the mundane things that a publisher does, as far as getting your songs listed in the PROs or whatever. Yeah. But no, it's not 100% guaranteed that it's always going to be 100% goes to the publisher. A lot of times, if there's no advance involved or a very low advance, then you can get to retain some of the publishing just because you're not getting the benefit of the advance. Excuse me. The type of music that you're doing, there's different, more or less, not standards, but standards on who gets what share of the publishing. There's also differences on retention. Nashville in country music, it's typically a life of copyright retention for the publisher. And more of your pop, rock genre is, at some point in time, it's going to revert back to the writer. So it's there's no one answer for all of that. It's a lot of variables to go into it.
And Matt, is a 100% publishing deal actually 100%? Is it like you're giving 100% of your share away?
You're giving 100% of the copyright ownership. On a 100% deal, you get 50% of the money.
So it's an important distinction you just made. Nashville and country music are very much a world unto themselves. I deal basically in everything but country. While I've increased my frequency of trips to Nashville, I deal primarily in pop and rock, hip hop and R&B, and it's an entirely different publishing paradigm in that world. Even the way you split the copyright. So in Nashville, generally it's split equally by the number of writers who work on a song. It's very egalitarian, very Bernie Sanders-esque. Not gonna get into politics, but anyhow, whereas with pop, rock, urban, etc., it tends to be 50% for the track or the musical bed, and 50% for the top line writers who write the lyric and melody. Now, when it comes to publishing deals, there are of course two primary categories. There's co-publishing, right, where you are actually you are conveying or assigning 50% of the publisher's share to the publisher. Okay, and you're retaining 100% of the writer's share. The writer's share is what is accounted to directly from ASCAP, BMI, or CSEC. That is always excluded. So be very wary of any publishing deal that where you're assigning the writer's share. Okay, that's co-publishing. And then to his point, with co-publishing, there's a varying retention period. So there's what's called a full reversion, where that 50% of the publisher share that you've conveyed to the publisher will fully revert to you after a certain number of years, or generally it's the later of a certain number of years, or a full recoupment of the advance. Okay, or there's a partial reversion, where only the administration rights revert to you after a certain number of years. Then the other primary category of publishing deals, of course, is administration, which is what I would suggest more often than not, as a real artist, songwriter, advocate myself. Unless a publisher is paying you life-changing money and or rendering legitimate creative services, why give them some or all of your copyright? And I know we may diverge on this, and et cetera, but I'm an artist guy. I've never worked for a publishing company. I don't represent publishing companies. I represent artists and songwriters. So copyrights are all you have. So there needs to be real consideration involved for you to assign 50% or 100%. So administration deals, you retain 100% ownership. What a concept. Right? And you're only paying a very small administration fee. To me, everyone should be doing administration deals unless they're paying you a gigantic advance, or whatever gigantic means based upon the songwriter's circumstances, and or rendering real, tangible, creative services. And way more often than not, in my vast experience in this industry, creative services are few and far between among publishers. They may say they'll do it when they're pitching you, but they rarely do it. Generally, it's passive incoming requests, that's it. If a song is charting on radio, then they've got a lot of heat on it. The water's warm, it's easy to place things in TV and film. But you need someone who's really going to roll up their sleeves and grind it out for you. So I wouldn't even be considering, so I think everyone should be self-published unless they have real leverage to negotiate publishing deals. And also, soliciting publishers, I think, is a huge mistake. I think publishers should find you based upon your success and your notoriety and reputation.
Jeff, did you want to?
Well, both these guys refer to it, but you know, Nashville is a whole different animal when it comes to songwriting. It is very much a blue-collar town. Long history of songwriting, like workaday songwriters, you know, clock in and clock out. And historically, what you give up for that, or what comes with that is 100% conveyance of copyright. I do think that is changing ever so slightly. As Nashville has been more and more influenced, not only creatively, but from a business standpoint, from you know, other genres and other people who have, you know, moved in from other markets and other genres. I think that is changing, but there is a long-standing tradition, again, of sort of being a lunch pail songwriter. And sort of to Jeremy's point, there's a different expectation as far as creative services in Nashville as well. If you sign up with a bona fide publisher, there is a certain expectation that you will get those type of creative services that really do help you establish as a songwriter. A lot of sort of creative service providers in Nashville are almost, you can almost view them as like a personal trainer. They'll keep your calendar, they'll give you feedback on your songs, they'll certainly help set up co-writes for you. It is a more personal, almost management type relationship between publisher and writer in Nashville. If it's a good, so Nashville again being sort of a different animal here.
Yeah, so thank you for further clarifying exactly. Nashville, it sounds like publishers are more managerial. Outside of Nashville, basically for all other genres of music, look to management more than the publisher.
Great question. Any other questions?
So I'm an independent electronic producer, and I also have a record label that I'm starting with some friends, and we do a lot of heavy sampling in our work, and I've been researching what is considered fair use and what's not. There's really not a clear answer for that, and we're putting out more music online, and we're going to be making physical copies, and I just want to make sure that our artists are protected. What are the best steps for me to do that?
It's maybe a bit of a back and forth. Let me answer a question with a question. It depends what's involved, right? So fair use is a very, very interesting idea/question. So of course, sampling, I'll assume that you're actually incorporating an existing master into yours.
Yeah, even sometimes samples from films, I guess the master audio of that film.
Sure.
Or songs, or random things that we find on YouTube or whatever.
Got it, as opposed to an interpolation, and you're familiar with the distinction? Okay, so an interpolation, right, is when you're actually recreating something, as opposed to physically sampling an existing master. So those are two entirely different analyses, right? Of course, with sampling, you have to clear both the master side, which is generally through the catalog record label, assuming the artist whose work you sampled put that master out through a label, as well as the publishing side, through the publisher, versus an interpolation where there is no master side. And that's why often people interpolate instead of master, because you're removing half the clearance effort. There's no master, there's no label to deal with, you're just dealing with a publisher for the underlying copyright or musical composition. So now there are many schools of thought on this. I think in this climate where the playing field is very much leveled and everyone has distribution just by virtue of having a phone, I think what rises to the level of commercial exploitation. So I think there's often a lot of what I'll call benign neglect, meaning if something's not being sold, basically, people will often not pursue it. It's analogous to a world that I know very well, the hip-hop world, where artists who are signed to labels exclusively are putting out mixtapes, promotional mixtapes. You know, notable artists like Lil Wayne, that's how they made their career. So when I say benign neglect, the label could claim the artist breached their deal by putting something out promotionally for free, but they don't do that because ultimately it benefits them. So while technically it's copyright infringement, it's a mutual benefit, so it's not prosecuted. And I would say the same applies or similarly, with sampling. If it's just promotional, if it's kind of below the radar, then I don't think there's really much of an issue. Of course, formally speaking, I wouldn't advise you to infringe anyone's copyright on the record. Jeremy Rosen advised me I can do whatever I want.
This is being filmed, just
another unnecessary lawsuit. So ultimately, it's just for promotional. All joking aside, though, I think in this culture of mashups and mixtapes and remixes, I think really everyone encourages that. I think sampling is one of the highest forms of flattery these days. And as long as you're not you're not cannibalizing their market at all. So as long as you're not formally selling something, say on iTunes or Amazon or where or some prominent Spotify playlist, but oftentimes these days, and this is kind of ironic but poetic, up and comers such as yourself, right, who are building a fan base and a career, you'll do things which technically may be unauthorized, but then they're so hot and they create such traction that then they become authorized, right? Then word gets back to Drake or Steve Aoki or whoever you're sampling, and they go, you know what? That's amazing. Let's clear that. Let's put it on the deluxe version. I'm going to do a new verse and put it on that. It becomes a whole thing. So informally, without any attorney-client relationship here, I would say I would encourage you to sample and get very creative. Just don't sell them formally. And of course, sometimes you're a victim of your own success, where if it pops off enough, then you will be on the radar, and then you may need to clear it, but you can have worse problems than being on the radar, because then you've got room to negotiate.
Until you're on the radar, most likely you're not going to get anybody on the phone to get a clearance anyway. That's one of the things that aggravates me with a lot of record companies and publishers. They want to protect their rights, and they don't want anybody to infringe, but their licensing people are frankly kind of lazy and don't return phone calls and emails and do what they need to do. Since we are being filmed, fair use is a very foggy, murky concept, I would say he's probably the right train of thought. Do it and then ask for forgiveness and negotiate if something happens.
I'm not plausible deniability.
Awesome, great question. Any other questions so far?
Yeah, we were back there talking, and we can hear you. That's right. And I asked 2 questions, and one of them I think maybe segues into the social time. The first was kind of what you're talking about with sampling. It sounded kind of like trademark rights, in a way. And I know there's been a couple bands in Asheville that have been contacted by bands in like Chicago or somewhere that are like, hey, you can't use that band name. So I don't know if you can speak to that as far as like band name crossover kind of thing. And the other is that we're sitting in this room, you guys have made yourself accessible, but the same way you kind of cringe when people ask about fees. I think a lot of us cringe when we think about, I got to talk to a lawyer. So like, how do you advise like getting over that hump and being like, I gotta go talk to a lawyer? And like, how do you broach that and not feel intimidated and like I'm gonna have to pay a fee to go have a meeting with this guy and figure out what I gotta do?
You're talking to us.
It's my cousin, so I'll as far as approaching a lawyer, as Jeremy was touching on earlier, this is niche of niche, and most of us, this is what I wear. This is actually me dressing up. Our office is in Nashville. We have purposely created an informal space. It's a place where artists feel welcome, and if you can imagine, some of our clients even come by just to hang out from time to time. So we think of it as a very inviting space. There are other attorneys I would assume that are a little more intimidating as far as their own personal approach and the way they run their office. But we're all sort of black sheep renegades of the legal profession, I suppose. Like I mentioned earlier, most of us, had to really sort of scratch and claw our way up in this business, akin to what you guys are doing too. So I think there's a certain, kindred spirit between music, attorney, and artist. And the more of us that you get to know, I hope that you find the same.
When my wife introduces me to people that she knows that I don't know, she says, he's not a real lawyer, he's an entertainment lawyer. So, and as far as dressing, I'm older than these guys, so I dress a little bit more traditional. I'm too old to look cool and something like that. We work for our clients, so that's one thing you should have when you're going to go talk to an attorney for the first time is you're going to go talk to somebody that is obligated to look out for your best interest and that works for you. At the same time, you need to listen to that person because he or she has been there before and is going to have knowledge that you probably don't have. So, but they do work for you. You talked about trademark. Trademark rights are based on use. Registration is something that you should do with your trademarks, just like you should register your copyrights. It gives you better ways to protect your rights. But basically, whoever uses a trademark continually with a certain type of good or service, the first one to use it has the rights. There have been a lot of bands that did not perform a trademark search. They chose their name, and for years everything's fine. Then they get a deal, they're big time, and they can't go into the state of Wyoming because there's another band that's been playing for 30 years with the same name. Then they go through a lot of expense trying to buy the rights of that person. So when you're choosing a band name, you really, you can trademark, as far as legal fees go, you can spend as much as you want. The best thing to do is go to an attorney, have them perform a trademark search, give you an opinion on whether or not you should move forward with that name, and then go through the registration process. That's going to cost, just ordering the search itself is usually about $700, then the time to look at it. So it's not going to be cheap, but it's one of those things that it's a lot easier to get it right in the beginning as opposed to a year or two down the road. You got Facebook, you got all your followers, and all of a sudden you got to come up with a new name.
So starting with the intellectual property hierarchy, as I'll call it, copyrights being by far the easiest to achieve a registration, then significantly more difficult trademarks, and then by far the most difficult patents for inventions. These three distinct categories of intellectual property are often incorrectly substituted and interchanged for one another. So trademarks, that's right. Whoever is the first to use the trademark in commerce tends to have the rights. Even if someone subsequently achieves a trademark registration, it can still be challenged based upon prior use. It's a very delicate, deadline-heavy process. I used to practice trademark law myself. I don't any longer, frankly, because it would trigger a much higher malpractice insurance for me, and God forbid I miss a deadline. So I prefer to engage outside trademark counsel who's focused exclusively on those important deadlines as well as enforcement and prosecution. And there's a wide range there as well. How diligent you want to be regarding trademark use. So let's say you have achieved a trademark registration. How actively will you or someone on your behalf police those rights? For instance, one of my clients came to find out recently that there were a chain of barbershops utilizing this client's registered trademark, unbeknownst to the client or unbeknownst to me. So there are many ways to proceed. I don't want to get too far off on a tangent, but we can either blanket these barbershops with cease and desist letters to the effect of, here's our registered trademark, stop what you're doing. Or you can take perhaps the more pragmatic approach and try and work out a deal. Try and put your trademark to use for you. And perhaps you negotiate some kind of royalty where you allow them to continue using your trademark subject to certain payment obligations. Of of course, you want to make sure that there's some quality control, so the barber shops are not in any way diluting or prejudicing your brand. But back to you used the band Chicago as an example. So again, there is a lot of misconception about utilizing words within, say, song lyrics, versus a trademark, which is essentially a brand name for a good or a service. Again, copyrights use all sorts of words interchangeably. Generally, Chicago, of course, is the name of the city, it's the name of the band. There are some hallmark trademark cases, like McDonald's, of course, being probably one of the most notable, where there are many people with the surname McDonald's who are unable to use their actual last name based upon the trademark registration for the fast food restaurant McDonald's. So there are all sorts of intricacies there, but certainly the trademark process is not one to be undertaken lightly. It is costly. And again, until you actually use a trademark in commerce, it cannot achieve a trademark registration. So you have up to 6 extensions of time to use a trademark in commerce. So 6 extensions of 6 months each. And of course, each extension triggers another fee to the United States Patent and Trademark Office, as well as fees to your trademark lawyer. So again, it's not to be undertaken lightly. So unless and until you're actually ready to use a trademark in commerce, I would probably hold off, unless there's some kind of urgency, you feel like someone else may beat you to market. I can go on and on, but I'm the king of digressions and tangents, so I know you want to get on with your Sunday. But getting back to attorney-client, again, to repeat what I said earlier, niche of niche. Well, yes, we all, despite being relatively casual, etc., and living by the beach, that in no way our attorney-client relationship remains as important and as formal as you'd find in a more traditional law firm environment. So there's nothing casual about how we treat our ethical code or how we prioritize our clients' affairs. However, and I know this is easier said than done, there's nothing to be intimidated about. We are fans first. I think that's why we got into this business, or at least I hope it is. Again, if it were all about the dough, we'd be doing something more traditional, more lucrative. So I think you should see us as artist advocates. Of course, not every relationship is destined to yield an attorney-client relationship, but these should be informal meetings. I think if anyone's charging you for an initial meeting or consultation or email exchange, that's a huge red flag, dare I say a non-starter. It's not about that. It's not that the clock is not ticking until it's mutually understood to be ticking and there's real work to do. I know many of my music lawyer colleagues and friends feel the same way. So despite being attorneys from a formal standpoint, we are, again, the black sheep of the legal bar. And ultimately, we're just, I like to think, good people who are looking out for artists, while of course trying to earn a living at the same time. But I go out of my way to try and strike a proper balance. And the moment that I am in any way neglecting a client or a potential client, I think it's the moment that I should not be involved. And I have to remind myself of that all the time. To me, it's very much quality over quantity. I'd be doing a disservice to a client or a potential client if I couldn't devote more than adequate resources, time, and attention to that client. Otherwise, why get involved? They should be with someone who's willing to do that.
All right, thank you. Looks like we have one more question.
Thank you. I put out 2 albums with a large indie label, and I signed a publishing deal with their publishing wing. And it was, I think, a standard Nashville deal. I see royalties from it, but sometimes I'll get emails from YouTube if I put up my own version of the song saying that I'm violating the license, and I'm wondering if that's
Assuming you signed an assignment of copyright, someone else at least controls that master. Again, without going into all the intricacies, I personally don't know, how YouTube necessarily polices copyright, but I would think that something is being triggered because you are not the controller or owner of that particular master recording. Oh, your own song. Okay. Again, it may be that you assign the copyright to that particular composition to the publisher, and that's what's triggering it. I see it all the time with SoundCloud, actually. Just complete takedowns of my own client's music because there is some perceived encumbrance.
My 2 cents, I would loop in the relevant individual, in your case, at your publishing company, through either the publisher's existing contact at YouTube, or even just a very general DCMA notice, or whatever the speed resolution contact is on the YouTube site. Loop in the relevant individual, your publisher, to evidence your permission to post a cover of your own composition, right? So, but I think that's absolutely right. Ultimately, it may just be some kind of blanket knee-jerk response where they have your publisher on file as the exclusive copyright owner or administrator of that copyright. So it's probably just a formality where you loop them in and you become another authorized user or representative of that copyright.
So if this happens to anyone else here, we can connect you to the Maiden Network that came and did our YouTube monetization workshop. We can ask them to look into who actually, look on the back end, who owns the copyright and why that's happening. Yeah, but that happens on SoundCloud too, because we do that when I upload music for local artists onto the Explore Asheville website, and I'll get a notification that we don't have the right to do that, even though we have a license agreement, and we have to go back and let SoundCloud know that we have an agreement to upload their music to, on behalf of the artist for the Explore Asheville radio site. Thank you.
All right. Fantastic. I think at this time we're going to leave the floor open for everybody to have a little bit of social time. Feel free to make yourselves known to these gentlemen. I want to thank our friends Jeremy and Matthew and Jeff for being here today. They came from Asheville. I want to make sure that I can thank the gentlemen of IMABL for recording today. Today's panel discussion can be found on their archives at imabl.com, as well as all the other panel discussions that we've done here with the Asheville Music Professionals. They're a fantastic resource to revisit some of this information. Of course, Asheville Music Professionals is here also as a resource directly to you guys. Always feel free to reach out to us with any of these general kinds of questions, and we can hopefully help connect you to the right person. I want to thank the folks at Bonfire Barbecue for having us today, and most of all, I want to thank all you guys for coming out, listening, and engaging with the panel. We really appreciate it, and look forward to shaking some hands and saying hey.